now from Mr. Jackson.
Thank you, Your Honor. Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And woe betide any one of us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth, how he would make sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie. Over and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that can happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person, and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen right in front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Read. They desperately resorted to calling witnesses to talk about Karen Read and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up until the time Karen Read dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Kenton family, it's easy to say, I didn't see something, because how can that really be challenged? Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And then when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps. and you're descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie, and Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. So it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial. How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing? Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They had been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied, and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know. and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his in testimony that he provided. Quote, "I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers." Remember that testimony. So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, "You know, your girl's been texting me"? A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First he said it was administrative work, then he said he was moving cars, then he said it was a factor of both. Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jen McCabe admitted, "Yeah, I didn't see her there." But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog. And Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day, at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now that call is odd and suspicious enough, in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, they're butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds? Maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3:30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with a Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house? The side where John's body was found. And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabes, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John, he walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back, he's not responding, minutes start to pass, 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. And being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up, she's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. "John, where the fuck are you?" She says through tears and desperation. And at 6:03, her question was answered and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it. Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. You can see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished when Dighton Police Officer Barros walked into this courtroom. He's a sworn officer. He's not associated with Kenton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged." Take a look at this photograph and tell me, which one looks like Officer Barros's description? The one on the left or the one on the right? The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank a very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed, what with that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too. And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody. An outsider. This is going to be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second. Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alberts. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself. And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor. So the glass on the bumper had to be placed there, and the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside. That would be a magic hair indeed. That magic hair means nothing. The DNA means nothing, and that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight, the taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces, and no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted. It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mullaney, Michael Lank, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools, a leaf blower. Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate. Tully, however, claimed that 1 red piece was found. About 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about, those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not Stop and Shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew? There's evidence tape around here. So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember, he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. pulled out 2 red pieces of plastic. And I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic right before your eyes. Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sallyport video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sallyport that same afternoon and evening. And then the Sallyport video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sallyport together. Where were they going? Remember O'Hara? Unidentified troopers in Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses, and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts, that's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any, there's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house, that SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto-pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but 2 thoroughly credentialed medical examiners, or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rentschler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement before coming to his final resting place with his unbroken phone tucked neatly under his body. It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rentschler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation. Those secret group chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object. And he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth, and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
All right. Thank you very much, Mr. Jackson. All right, Mr. Lally.
Thank you, Your Honor. I hit him, I hit him, I hit him, I hit him. Those are the words of the defendant. 4 times. You heard testimony from 4 different witnesses who overheard and observed those statements from the defendant on January 29th, 2022. You heard testimony from firefighter Timothy Nuttall. He was trying to bag, valve mask Mr. O'Keefe. He was working on resuscitative efforts to try to save Mr. O'Keefe's life. He asked if anyone saw anything or knew what happened, and the defendant said, I hit him, I hit him, I hit him, I hit him. Firefighter Anthony Famati was asking if anyone had information on why Mr. O'Keefe was there in the snow. The defendant repeatedly said, I hit him, I hit him, oh my God, I hit him. Firefighter Katie McLaughlin was tasked by firefighter Flamati with asking for biographical information and for what the cause was of the traumatic injuries that all the firefighters testified that they observed on Mr. O'Keefe. She asked the defendant, and the defendant said, I hit him, repeatedly. Firefighter McLaughlin asked for clarification. You did what? And the defendant repeated, I hit him. Jennifer McCabe stated initially over the phone when speaking with the defendant that the defendant said, could I have hit him in the car while they're on the phone with Ms. Roberts going from Ms. McCabe's house to Mr. O'Keefe's house? Did I hit him? Could I have hit him? Once on scene, once asked, as Ms. McCabe described by an EMT, for name, age, things like that related to Mr. O'Keefe, what caused the trauma? She indicated in her testimony that the defendant said repeatedly, I hit him. You heard testimony from Officer Sarif, statements that he attributed to the defendant as saying that morning, this is all my fault. This is all my fault. I did this. This is what the defendant is saying on scene. Since then, the story's changed a little bit. But those were the words that came from the defendant's mouth on January 29th, 2022, as John O'Keefe lay dying on the front lawn of 34 Fairview Road, where the defendant had left him after striking him with her motor vehicle several hours before, and then left him freezing there in a blizzard. There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a 3-card money trick. The facts and the evidence in this case are your card, they're the Queen of Hearts. And so what I want you, or what the defense wants you to do, is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the 3 indictments before this court. The evidence and the facts of this case are for you, the jury, to decide. Using your common sense, using your life experiences as your guide through that as you go. Before I turn to that evidence that I will submit to you ineluctably demonstrates the defendant's guilt, let me first just address Trooper Proctor. The text messages from Trooper Proctor are unprofessional, they're indefensible, They're inexcusable. However, as distasteful as those messages are, and their content is, I submit they had no bearing whatsoever or impact whatsoever on the integrity of the entirety of the investigation that Massachusetts State Police collectively conducted into John O'Keefe's death here. As was asked of Trooper Proctor on cross-examination, these were texts from his personal phone that he never thought would see the light of day. He was asked whether or not he ever thought that he would be asked about these in a courtroom, put to him in sort of a safe space, a safe place for him to discuss, if you will. What do you not see in those text messages? You don't see any discussion or any illusion of any conspiracy, of any framing of the defendant, of any planting of any evidence, no evidence whatsoever. Why? Because it didn't happen. There is no conspiracy, there is no cover-up, there is no evidence of any of that beyond speculation, rampant speculation and conjecture on behalf of the defense. Two things can be true at the same time. They're mutually exclusive. The texts from Trooper Proctor are distasteful, they're disrespectful, they're unprofessional, there's no defense to them. And the defendant killed John O'Keefe. Turning to the evidence, let me first talk a little bit about John O'Keefe. You heard a lot about him over the course of this trial, about his selfless story through his family and friends that loved him, including his adopted niece and nephew. You heard a lot about the lives he touched and the different people who he had friendships with. You heard a lot about from those particular friends and from his family. Turning to what I would submit to you as a timeline. This may be a little hard to see up here. What I'm going to go is from left to right. January 28th, 2022, 9:49 in the morning, Karen and John begin fighting over text messages. 2:25 p.m. in the afternoon, the defendant texts Mr. O'Keefe, "Tell me if you are interested in someone else. Can't think of any other reason you've been like this." John texts back, "Nope." 2:25, Mr. O'Keefe texts the defendant, "Things haven't been great between us for a while. Ever consider that?" And this is also testimony that you heard through multiple sources, whether it be phones, whether it be from the children, whether it be from other friends or family members as to the relationship in the months and weeks leading up to John's murder. 2:32 p.m. John texts the defendant, "Sick of always arguing and fighting. It's been weekly for several months now." He then texts the defendant, "OMG, stop calling." This is during the time frame that Trooper Garino was talking about, with 18 phone calls, most of which were rejected, some of which were missed, and a couple of which were answered over the course of this afternoon, as she's continuing to needle and try to engage him in a fight that he doesn't want to have. 2:33 p.m. The defendant texts John, "So you're not into this anymore." 2:34 p.m. John texts the defendant, "I am not answering, stop calling." The defendant then texts John, "Then stop starting with me." 2:38 p.m. The defendant texts John, "I'm going to grab a drink in a bit." 2:38 in the afternoon. Around 3 p.m. is the testimony you heard from Erin O'Keefe in regard to the defendant texting her, asking if she can go out without her husband, Paul, asking to go out for a drink. This is while Erin O'Keefe testified she was waiting for one of her children at the bus stop, picking that child up around 3 o'clock in the afternoon. This is also the point at which the defendant says to Ms. O'Keefe, "Wish I didn't speak to another O'Keefe after 2004. 7:30 p.m., you have Mr. O'Keefe and Mr. Camerano arriving at C.F. McCarthy's, with the defendant arriving at 8:51. 8:58 p.m. is when the defendant receives drink number 1 at C.F. McCarthy's. Vodka soda, tall cylinder glass, lime, and a straw. 9:13 p.m., drink number 2. 9:20 p.m., drink number 3. 9:33 p.m., drink number 4. 9:57 p.m., drink number 5. 10:22 p.m., drink number 6. 10:29 p.m., drink number 7. 7 drinks from 8:58 p.m. through 10:29 p.m. when she receives that last drink at C.F. McCarthy's. The drink that she indicates to Sergeant Mechanic and several others on the next day that she did not take with her from C.F. McCarthy's to the waterfall, which several individuals at the waterfall testify that she produced from her coat when she walked in, and that you can clearly see on the C.F. McCarthy's video her walking out the door with the same tall cylinder glass in her right hand. Now, understanding that some of these drinks are not the full tall cylinder drinks, what she's doing is she's getting shot glasses of vodka and then pouring them into the drink after she's consumed the drink. 10:54 p.m. The defendant and Mr. O'Keefe arrive at the waterfall, during the course of which, on an hour that they're there, the defendant receives drinks number 8 and drinks number 9. 12:10 a.m. From the waterfall video, you have Ms. McCabe, Ms. Kolokithis, and the defendant departing the waterfall together. Interestingly, around the same time, you also have the text and screenshot communications between Colin Albert and Allison McCabe in reference to him getting picked up at that time. You also have testimony from Brian Albert, Nicole Albert, Caitlin Albert, Brian Albert Jr. in reference to them sort of walking in from the waterfall as Colin Albert is walking out of 34 Fairview Road, gets picked up by Ms. McCabe, and then is driven home. 1 minute later, 12:11, Mr. O'Keefe is then on the waterfall video walking out with cocktail glass in his right hand. At 12:14 a.m., Mr. O'Keefe texts Ms. McCabe, "Where to?" 12:14 a.m., based on the fact that she's driving, and Matt McCabe indicated in his testimony that she should call him instead of texting while driving, Ms. McCabe calls John O'Keefe and speaks with him regarding directions, sort of going over which way to come in, Chapman Street, over Cedar Crest, as far as coming into Fairview Road. 12:15:38 a.m., the defendant's vehicle drives by the Canton Library. You can see that on the video. 12:17:56, the defendant drives by the Temple Beth Abraham video. Again, you can see that on the video. Remember also the testimony from Lieutenant Tully in regard to the CSLI data and the ranging data in reference to it coinciding with what you observed, the black SUV, from each of those respective videos. 12:19:32, Mr. O'Keefe enters 34 Fairview Road into his Waze app on his phone. 12:23 a.m. is when the defendant conducts a 3-point turn on Cedar Crest and travels back toward Fairview. That's from Mr. O'Keefe's GPS native location data from his phone. Around the same time at 12:23 and 12:24 is when you have that testimony from Ryan Nagel, Heather Maxon, and Ricky D'Antono pulling into Fairview Road around the same time and pulling in behind the dark SUV. 12:25 a.m. is the last native location GPS data of John O'Keefe's phone. It's in that area between 32 and 34 Fairview Road where his body is discovered the next morning, in which there is no movement of that phone from that 12:25 a.m. period until Ms. Roberts then picks up the phone on the grass underneath Mr. O'Keefe's body sometime after 6 a.m. What you have up on the screen right now is that data, those plotting points that Trooper Garino was testifying about as far as the movement of the vehicle. The movement of the vehicle as it comes down Cedar Crest, passes by Fairview, reverses direction, and then comes down Fairview, moving up, moving up, moving up, as the witnesses described, eventually stopping in that area of the property line between 32 and 34 Fairview Road, which happens to coincide with the vehicle control history database information from the Toyota text stream, which you now have up on the screen before you here, indicating that following that 3-point turn, approximately 8 minutes after that, from Trooper Paul's testimony, as far as the mileage, 36 to 38 miles, matching up with the time that the vehicle is in front of 34 Fairview Road, that the vehicle travels in reverse, in a straight line, for 24.2 miles per hour for 62.5 feet, with a minor steering angle change, which the trooper indicated was consistent with a pedestrian collision. At 12:30 a.m., you have that second triggering event 8 minutes after the three-point turn when the vehicle's in reverse at 24.2 miles an hour. 12:35 is when the defendant calls John, and that's unanswered. 12:36 is around the time that the defendant's phone connects to the Wi-Fi at 1 Meadows Ave, Mr. O'Keefe's home. 12:37 is when the defendant leaves this voicemail. So within minutes of that vehicle's data, going 24.2 miles an hour in reverse for 62.5 feet, the defendant leaves that voicemail, seething in rage as she's screaming, "John, I fucking hate you." 12:40 to 12:42, Ms. McCabe is texting Mr. O'Keefe. She tries calling Mr. O'Keefe, gets no answer. If you recall from her testimony around this time frame, about 12:40, she was unsure whether the vehicle was actually still out front or if it had gone at that point. But she was looking for John because she had seen the defendant's vehicle in front of the house and no one had come in. So she was wondering where her friend, Mr. O'Keefe, was. 12:55, the defendant texts John, "See you later." 12:59, the defendant calls, leaves another voicemail for Mr. O'Keefe. Exhibit 637, it sounded like this.
"John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert."
But somebody did know where Mr. O'Keefe was. The defendant knew exactly where he was. She had driven him there, she had struck him there, she had left him to die there. 1:02 a.m., the defendant leaves another voicemail with no content. And then she texts John, "Your kids are fucking alone." 1:09 a.m., the defendant texts John, "I'm back in Mansfield. The kids are home alone." She's not. GPS, as far as it never disconnects from the Wi-Fi until the following morning. There's no indication that Ms. Reed left and went to her home in Mansfield at any point in time. 1:10 a.m., the defendant calls her parents. 1:11 a.m., she calls Mr. O'Keefe and leaves this voicemail.
"John, I'm going home. I cannot babysit Amy. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself."
1:18 a.m., the defendant leaves another voicemail. Now, about 1:43 or 1:45 a.m. is when Julie Nagel testified that they were leaving the house. And she sees a large black object on the lawn near the flagpole while leaving 34 Fairview Road. Doesn't think much of it at the time, isn't expecting Mr. O'Keefe or any body to be out on the front lawn. 4:42 a.m., the defendant calls and speaks. The calls to her parents are finally answered. 4:49 a.m., the defendant calls Ms. Camerano, screaming, "Where's Mike?" 4:53 in the morning is when the defendant instructs Kaylee, Mr. O'Keefe's niece, to call Ms. McCabe. Why? Because the defendant doesn't have Ms. McCabe's phone number. Indicates that John didn't come home. We got in a fight, and I left him at the waterfall. Those are the first statements or the first version of events that she's able to communicate out to the world as to what happened to Mr. O'Keefe and where he is. We got into a fight. I left him at the waterfall. 5 a.m., the defendant calls Kerry Roberts, saying, "John's dead, Kerry, hangs up the phone. 5:01, the defendant calls Kerry Roberts again. And it's at this point that she indicates that John's dead, he must have been hit by a plow. 5:07 a.m., the defendant leaves 1 Meadows Ave. You have the video of that. It's number 153 in Exhibit 6. We'll get to that a little more in a moment. About 5:10 a.m., the defendant calls Kerry Roberts. Ms. Roberts starts calling hospitals, calling KPD, calling 911. Something that you would do if you didn't know where Mr. O'Keefe was for all of these hours, that all of these other phone calls are being made and these text messages are being sent and calling your parents and all of these other things. No calls to 911 from the defendant. While John O'Keefe is laying, freezing, and dying from a brain injury and a skull fracture on the front lawn of 34 Fairview Road. 5:11 a.m., The defendant's vehicle is seen on the Canton Library camera heading towards the waterfall. Seems to be sort of retracing steps. 5:18 a.m. The defendant's vehicle is seen at Washington Street and Chapman on the Temple Beth Abraham video, heading in the same direction that it was the night before when it was heading to 34 Fairview Road. 5:35 is when the defendant arrives at Ms. McCabe's house. Ms. Roberts arrives shortly thereafter. Both of them see the broken tail light at that time in the driveway. Now that gap of 5:18 to 5:35 is way too much time to be driving from the area of the waterfall to Jennifer McCabe's house. And as I indicated a moment before, heading in the same direction, same directionality, retracing the steps from the night before, heading towards 34 Fairview Road. Why is it that the defendant can see Mr. O'Keefe when they eventually get to Fairview Road and no one else can? It's because she knew exactly where he was. She had hit him and left him there the night before, and she had gone back during that time frame between 5:18 a.m. when she's seen on the Temple video and 5:35 when she arrives at Ms. McCabe's house. 5:33 is when the defendant, Ms. McCabe, and Ms. Roberts return to One Meadows Ave searching for John. 6:03 is when the defendant, and no one else, spots Mr. O'Keefe's body buried in the snow. Exhibit 12, indicating this cruiser camera video, which I know you've seen a dozen times. So where I'm starting it from this point in this card right here is the spotlight that Officer Saraf had to use in order to locate, even with the vehicle of Ms. Roberts parked right in the middle of the road. In the darkness, in the snow, in the blizzard, in those conditions, the defendant, sitting in the back seat of the vehicle, knows exactly where Mr. O'Keefe is, covered in snow, as you heard from all of the paramedics, from the civilian witnesses, from the first responders. But the defendant knows exactly where he is. 6:07 a.m., Ms. McCabe calls 911. 6:08, the defendant leaves that 4 or 5 minute voicemail, leaving the phone in the car for some reason to Mr. O'Keefe's phone. 6:23 and 6:24 in the morning is when Ms. McCabe conducts those Google searches. 7:50 in the morning is when Mr. O'Keefe is pronounced deceased at Good Samaritan Hospital. 4:13 to 4:20 p.m. is when the defendant's SUV is towed from her parents' house in Dighton. 5:20 p.m. is when the search team arrives in the area of 34 Fairview Road to conduct the search for evidence. 5:30 p.m. is when the defendant's vehicle arrives at the Canton Police Department south. We circle back for a moment to Mr. O'Keefe, to his families, to his friends, and to his relationship with the defendant. You heard testimony from Paul and Aaron O'Keefe that they liked the defendant, that they thought he was good for John, thought he was good for the kids. All outward appearances of the relationship were good. You heard testimony from the children that that was not true behind closed doors. But Paul O'Keefe testified that he told the defendant's parents this, that he liked Miss Ruth, that he thought that she was good for John, thought that she was good for the kids, weeks before John's murder. He even blew her a kiss in the emergency department at Good Samaritan as he was walking out and she was still being treated while they were there. Invited her over to John's house to grieve with him. Invited her to sit down with him while he explained to their nephew Patrick about John's passing. The defendant shows up at the house. Abruptly goes upstairs with her father for a period of about 15 minutes, which is about half of the time that she spent there that morning grieving with the family. She left with a bag of her belongings, drove with her family there, and then took an extra vehicle in the height of the blizzard now, around 1 o'clock in the afternoon, drives that vehicle all the way from Canton, where it was parked at boyfriend's house, where she stayed over on many occasions, drove that vehicle or felt the need to drive that vehicle from Canton all the way down to her parents' house in Dayton at the height of the blizzard. You heard testimony from Aaron O'Keefe of the text messages and the phone call on January 28th. You've heard that Aaron O'Keefe called the defendant on the morning of the 29th because she was concerned for her. She wanted to know what was going on with someone she considered her friend. The defendant yells, "John is dead." Ms. Robertson grabs the phone and then updates Aaron O'Keefe as to what's going on with John. Aaron O'Keefe again calls back later because she's concerned for someone that she considered her friend. How does the defendant respond? These are some of the little things. The defendant indicates to Ms. O'Keefe that she just has to remember the bad times and indicates to her, "I don't think I'll ever see you guys again." This is after she's done her quick in and out at One Meadows Ave and is now with her parents or with her father, driving that car, essentially taking the murder weapon from Canton and bringing it down to her parents' house in Dayton. She's indicating over the phone to Aaron O'Keefe, "I don't think I'll ever see you guys again." Why? If she didn't kill John, why would she say that? You heard a lot of testimony about New Year's Eve in Aruba. You heard the testimony from Ms. O'Keefe in regard to them exchanging, her and the defendant exchanging text messages on the flight down, arranging times to meet up. And then the defendant telling Aaron via text message that she caught Johnny kissing Laura's sister in the hotel lobby. She got into an argument about it, and then they never met up. Meaning the defendant, Mr. O'Keefe, got into an argument about it, and she and Aaron O'Keefe never ended up meeting up in Aruba. You heard testimony consistent from Laura Sullivan, Marietta Sullivan, as well as the children. The kiss never happened. It never would happen based on the relationship, the godfather relationship that John O'Keefe had with Laura Sullivan, her family, and particularly Laura Sullivan's child. The defendant persists with this unfounded suspicion and accusations of infidelity in her text messages with Mr. O'Keefe, in her text messages with Mr. Higgins, where she's accusing Mr. O'Keefe of making out in the lobby with Marietta Sullivan. Both of the Sullivans and the children have the defendant and Mr. O'Keefe following this incident with Marietta Sullivan going into a room. Both of the children testified that they're in that room for about 20 to 25 minutes and they're arguing about the defendant indicating that Mr. O'Keefe kissed someone in the lobby. And you have Laura Sullivan's testimony about 20 to 25 minutes after her sister comes out and states her displeasure about the defendant. It's about 20 to 25 minutes before Mr. O'Keefe comes out, and then he and Ms. Sullivan have a conversation. Ms. Sullivan indicates that Mr. O'Keefe's phone is essentially blowing up, lighting up with calls and texts from the defendant. I would submit similar to the afternoon of January 28th. Mr. O'Keefe says she's crazy and he needs to take this and goes off from there. Ms. Sullivan has later conversations with Mr. O'Keefe on this Aruba trip, asks him if he's okay, asks him if he's happy. She indicated in her testimony that Mr. O'Keefe shrugs it off and says it is what it is. You heard testimony from the children about the arguments in the weeks and the months. And I know this is a displeasure to the defense counsel that the children came in and actually testified as to what happened behind closed doors in the house. They both recall frequent fights. They both recall Mr. O'Keefe trying multiple times to break up with the defendant, asking her to leave the house, the defendant refusing to leave the house. His niece Kaylee, John tried to defuse, he tried to walk away, and the defendant would follow each time during each argument. They both indicated that Mr. O'Keefe had told the defendant that the relationship had run its course, similar to language within the text messages you have between the defendant and Mr. O'Keefe. That Mr. O'Keefe was sick of arguing, again, mirroring those text messages from January 28th, leading up into going out to CF McCarthy's, eventually the waterfall, and the defendant killing Mr. O'Keefe in the early morning hours of January 29th. We have the testimony in regard to the ring camera. Kaylee indicated in her testimony that John had had that for about a year. So during the course of the 2 years or so of the relationship with the defendant, he got it while he was dating the defendant. The defendant had the security code to the garage. Neither of the kids had access to the camera. Trooper Garino checked the laptop and the desktop that were left after the defendant did the quick cleanup upstairs with her father, upstairs in the home. Neither of those devices had access to the Ring cameras. John had access on his phone. The defendant indicates, if you recall, in some of those text messages in regard to the romantic kiss that she placed on Mr. Higgins earlier on January, whatever it was, during the Patriots game. Mr. Higgins, who Mr. Jackson was indicating weren't very good friends with Mr. O'Keefe, but had been invited over to his home for a Patriots game, in which time the defendant escorted Mr. Higgins out of the garage and placed a romantic kiss on him. But during those text messages, when they're talking about that, if you recall, the defendant is saying something or joking about something that Mr. O'Keefe had been looking at the videos and had been asking her if there was something going on with her and Mr. Higgins. And what was her response to that? I know where the cameras are. There are only 2 videos missing from that Ring system. One being the defendant getting to Mr. O'Keefe's house after murdering him, and the other when the defendant is showing Ms. McCabe and Ms. Roberts the broken taillight, both of which, both Ms. McCabe and Ms. Roberts testified as having occurred. No video of it. The variety of stories that the defendant tells on the morning of January 29th. There were text messages and voicemails from the defendant to Mr. O'Keefe, 53 phone calls from 12:33 a.m. to 6:03 a.m. 0 phone calls to 911. The defendant calls Katie Camerano. The defendant calls her parents at 1:18 in the morning, 4:38 in the morning, 4:42 in the morning. The call then from Kaylee's phone to Ms. McCabe, because the defendant didn't have Ms. McCabe's phone number. Both Kaylee and Ms. McCabe indicate that the defendant initially indicates or says that she got into a fight with Mr. O'Keefe and left him at the waterfall. From this information, Ms. McCabe then testifies she starts to call her Julie Albert. Because Chris Albert, Julie Albert, they live close by the waterfall. Maybe that's where he went. As the phone is ringing, and this is a phone call that both Ms. Albert and Ms. McCabe testify was never answered. As the phone is ringing, her husband Matthew McCabe reminds her that they saw the defendant and Mr. O'Keefe and the car outside of 34 Fairview. So she hangs up. During this call, or during these subsequent calls, the defendant indicates to Ms. McCabe, maybe I hit him, did I hit him? She then calls Ms. Roberts at 5 a.m. on the dot, indicates John's dead, hangs up the phone, calls back a minute later, indicates that Mr. O'Keefe was now hit by a plow and that he's dead. And then indicates further that she's drunk and doesn't remember. She tells Ms. McCabe about the cracked taillight before they even get in the vehicle and go anywhere, as you recall the testimony of Matthew McCabe, indicating that he had some concerns about them driving around in a vehicle with a damaged taillight in the middle of a blizzard. Ms. Roberts' testimony that she saw the broken taillight in the driveway at Ms. McCabe's house, and that it was consistent with what she observed in the photographs that were shown to her of it later in the Sally Port at the Canton Police Department garage when the search warrant is executed on February 1st. You have the text messages between the defendant and Laura Sullivan from January 29th, in which the defendant indicates to Laura Sullivan that John is dead, indicates that we found him in the snow at 5 a.m. And every indication is that he was found in the snow by the defendant, Ms. McCabe, and Ms. Roberts around 6 a.m. 5 a.m. would be about an hour before. 5 a.m. would be between that time where the defendant is unaccounted for, heading in the direction of 34 Fairview Road, 5:18, 5:35. Little things. The defendant asked Ms. McCabe to Google how long to die in the cold. She did so at 6:23 and 6:24 in the morning. You have the testimony of Ms. Hyde and Mr. Whitford as to SQLite databases, P-list databases, Knowledge C databases, state DB tabs, as far as all of that. Also from Trooper Garino as well. These searches were unequivocally done at 6:23 and 6:24 in the morning, and not at 2:27 and 40 seconds in the morning. They were not deleted by a user. That is not what deleted means. frankly, Mr. Green, the last question that I asked Mr. Green is, was he aware that Cellbrite, and by Cellbrite, the person who designed that being Mr. Whiffen, had to alter exactly how their software worked because of people like Mr. Green misinterpreting the data as he did in this case. And what did Mr. Green say? Yes. But those questions, as far as how long to die in the cold, I would submit mirror the questions that the defendant asked firefighter Whitley in the back of the ambulance, if you recall those. She asked firefighter Whitley how long to die in the cold without a jacket. She knew how Mr. O'Keefe was dressed. She knew when she left him to die in the cold how he was dressed. The defendant made statements to firefighter Becker that the last time that she saw Mr. O'Keefe, they were in an argument. Again, in the back of the same ambulance as firefighter Whitley. You have testimony from firefighter Woodbury. Same kind of questions. If Mr. O'Keefe could be alive without a jacket. You have the testimony from each of these firefighters as to sort of the vacillating emotional state of the defendant that morning. What you have in the testimony from firefighter Woodbury is that despite all that, there were no tears that he observed from the defendant at that time. What each of those first responders indicated is that the defendant repeatedly stated, is he dead? Is he dead? Not is he okay? Is he going to be okay? How is he? Any sort of questions about the medical condition. Is he dead? That phraseology repeated over and over and over again. And when you take into juxtaposition that phraseology, text to Laura Sullivan, found him in the snow at 5 a.m. The unaccounted for time heading in the direction of 34 Fairview Road, 5:18 to 5:35. The repeated questioning of firefighter Whitley, firefighter Woodbury, asking Miss McCabe to look up those things in her phone. She's looking for confirmation, is what she's looking for when she asks over and over again, is he dead? Is he dead? Is he dead? You have the testimony that you heard from Miss McCabe and Miss Roberts. I say them together because as far as these two women were concerned, they did not know each other, really at all. The only time, as they both testified to, that they had ever spent appreciably together prior to January 29, 2022, is when Mr. O'Keefe nicely took them out for sneakers because he had some sort of deal at a Reebok's outlet or something like that to sort of try to pay them back for the help that they provided him and the children. Jennifer with respect to the niece, and Kerry with respect to the nephew. But they're both contacted by the defendant in the early morning of January 29th. As Ms. McCabe testified, John was my friend. I love John, he was an amazing guy. At the waterfall, Mr. Albert said going home to have a drink with his son, Brian Jr., if anyone wants to come. Open invitation to the table. She said to Mr. O'Keefe and the defendant, you guys should come. Both the defendant and the victim indicated that they wanted to come and that they were coming. She describes the phone calls and the text messages that she receives from Mr. O'Keefe, that she's providing directions. She indicates she's providing them directions to go down Chapman. She describes how that is. And you've heard this testimony from a couple of different witnesses as far as the steepness as you're going down going down Fairview of coming off of Chapman. That you first go down a big, steep hill. It flattens out for a little bit, and then you go down a second hill. 2 hills going down on Chapman. Matching the GPS native location and the health data as far as where Mr. O'Keefe's phone is, a half mile away from 34 Fairview Road at the time that his health data is reporting that he's ascending or descending 3 flights of stairs. You hear the testimony from Ms. McCabe as far as the last time that she spoke to Mr. O'Keefe. And she's still trying to provide directions to Fairview because Mr. O'Keefe has never been there before and neither has the defendant, which is further corroborated in Trooper Garino's testimony as far as the vehicle passing by Fairview and then coming back in on the other side, having to reverse direction. But she's giving directions and she indicates that she uses a house that Mr. O'Keefe would be familiar with, that belonging to Bella or Bella's mom. Bella's mom is an ex-girlfriend for a short period of time from a long time ago. However, in the defendant's mind, it's so prescient on her mind that she's still talking about it the next morning or later on that morning when she's riding, going towards Fairview Road with Miss Roberts and Miss McCabe in Miss Roberts' car. She's still talking about that at that time. It's that much on her mind. Miss McCabe indicated that she looked out and she saw the vehicle initially in front of the front door, as did Mr. McCabe, as did Brian Albert Jr., as did Julie Nagel, as did Ryan Nagel, and the vehicle moved up several times or several spots to where it was then positioned. Initially at some point in front of the door, then it moves up further so that it's in the area of the fire hydrant and the flagpole where Mr. O'Keefe's body was discovered later on that morning, at least by Miss McCabe and Miss Roberts, and then moves up further beyond that. And I say that in the sense of it moves up further beyond that with sufficient distance for it to then go in reverse for 62.5 feet at 24.2 miles per hour, striking Mr. O'Keefe and leaving him where he was found later on the 29th. Again, the testimony from Ms. McCabe that about 12:40 when she's texting him, she indicated in her testimony she couldn't be certain if Mr. O'Keefe was still out front or had left at that point. She wakes up to a phone call from John's niece Kaylee at 4:53 in the morning. This is from an 8th grader, 14-year-old girl. That's why she answers the phone at 4:53 in the morning. She then hears the defendant screaming loudly over and over again, "Jen, Jen, Jen. John didn't come home, got in a fight, left him at the waterfall." The variations, the different iterations of that story as it evolves and changes over the course of that morning. Ms. McCabe then indicates to the defendant, "We saw you outside of my sister's house." Then she starts yelling, "Jen, Jen, did I hit him? Could I hit him?" Then they start discussing, or the defendant brings up her cracked tailbone. Then both Ms. McCabe and Mr. McCabe hear the defendant screaming outside of their home at about 5 o'clock in the morning, or shortly after 5 o'clock in the morning. They go to Mr. O'Keefe's house. And both Ms. McCabe and Ms. Roberts indicates, and you heard this testimony from a number of different witnesses, friends and family of Mr. O'Keefe, that he had a rule, pretty strict rule in his house as far as you take your shoes off when you come in the house. And so what did Ms. McCabe and Ms. Roberts both do when they're entering in that house on January 29th? They take off their boots, they get out in the snow, they take off their boots in the mudroom, and then they walk in. What did they both indicate that the defendant did that morning when she came back to the house? Just walked right in with the shoes. You hear that second voicemail. It's after the defendants arrived back at One Meadows Ave, after her phone is reconnected with Mr. O'Keefe's Wi-Fi. And you can hear the footsteps. Part of that may be in the garage, part of that might be in the house. Why is it that the defendant has no issue with wearing shoes in the house when Mr. O'Keefe has that strict rule? Because she knows where he is. She knows it's not an issue, he's not coming home, because she hit him with her SUV and she left him in the snow. Ms. Roberts and Ms. McCabe are frantically sort of running around the house looking for Mr. O'Keefe. The defendant's not. They then get in the vehicle. They drive back towards Fairview Road. And again, the defendant, from the back seat of the vehicle, immediately sees the defendant, starts pulling and kicking on the door, and runs in sort of a beeline straight over to where Mr. O'Keefe is laying on the front lawn. You have the testimony from Ms. Roberts as far as John's phone. John's phone, when the firefighters pick him up, and you recall several witnesses testifying about that, pick him up on the scoop stretcher and they bring him over to the ambulance while they're conducting the resuscitative efforts trying to save Mr. O'Keefe's life. But Ms. Roberts indicated that she observed underneath it, only the phone, but the phone on the grass. On the grass in the area that is completely covered in snow in every other area except under Mr. O'Keefe, which I would submit indicates how long Mr. O'Keefe has been there. Now recall, around 12 o'clock or so is when it starts to snow and it starts to stick a little bit. And you heard all that testimony. And I know it was a lot of testimony about snow and a lot of testimony about weather, but there's a purpose to that. There's a point to that, okay? As far as the grass underneath Mr. O'Keefe's body, where his cell phone was, and Ms. Roberts observes some 6 hours later after it starts snowing, is still visible only under Mr. O'Keefe where his body is, which I would submit as evidence to you as to how long he's been there. Now, on top of that, you also have hours of ring videos of the driveway as far as shoveling and Paul O'Keefe and other people snow blowing and shoveling and all those kinds of things. There's a purpose to that as well. If you look at those, if you look at the video of the defendant crashing into Mr. O'Keefe's vehicle at a speed of anywhere from 0 to 5, which even Dr. Wolf would indicate would not cause the damage to the taillight that was observed in this case. You know what you don't see? You don't see snow move off Mr. O'Keefe's vehicle when they come into contact. You don't see any red or clear plastic pieces in the snow. And if you look at those stills, not the ones that counsel put up there during his closing, but if you look at each of the video and the stills, you can see the damage consistent with the taillight at each and every point. You see the damage consistent with the taillight from the 507 video. You see the damage consistent from the 822 video from Lieutenant Ray from the cruiser camera video when he's pulling into the driveway. You see the damage consistent from the Dighton video at the defendant's home. You see the damage consistent from the right here, February 1st, 2022, when the search warrant is conducted and Ms. Hartnett removes all those pieces from the vehicle. The weather is also important when it comes to the hair. The magic hair, as Mr. Jackson likes to call it. See, the magic hair was actually frozen to the vehicle, as was the glass to the bumper, because the vehicle looked like that on the left when it was caked in snow, when Officer Barrow saw it in the driveway in Dighton as they were wading through 1.5 feet of snow, walking up, because remember, they didn't even pull into the driveway because they had to have someone come down and plow it before they could get into it. That's what the vehicle looked like. What you can see, however, is the damage to the taillight, to the side of that taillight, consistent with it. So that hair, that 7/8 of an inch hair, was frozen to the side. And as you remember, the testimony from Sergeant Buchanan about the heated condition of the Canton Police Department garage, and that's one of the reasons that they took it there, because the other barracks that they could have taken it to didn't have that heated condition. So yes, after it's been in there from January 29th at about 5:30 p.m. until February 1st when they conduct the search warrant, the hair isn't still frozen, as it's contained within a heated garage, and the pieces of glass on the rear bumper have melted. The snow has melted, as you can see from left to right. The weather, also important, I would submit, weather was a weapon. Remember, the cause of death here is not just blunt impact injuries, it's blunt impact injuries and hypothermia. And you heard all that medical testimony in relation to it, and you heard all that testimony in relation to the snow and the weather and the wind. Wind gusts up to 37 miles per hour while he's out, Mr. O'Keefe is out there in just a shirt and jeans. Now, you heard also testimony from Ms. Roberts in relation to the injuries she observed to Mr. O'Keefe, that initially on scene, there was one eye that was swollen, not the other. That's indication of the swelling that Dr. Scortibella was testifying to, and no indication of physical altercation. And then both eyes being swollen when Ms. Roberts viewed Mr. O'Keefe's body after his passing at the Good Samaritan. I submit that all the testimony tells you the same consistent account, internally, externally, from civilian testimony to investigator testimony to medical testimony to forensic testimony to the reconstruction testimony. You have the testimony from Ms. McCabe and Ms. Roberts that they couldn't see Mr. O'Keefe at Fairview when they initially pulled up. You can see that from Officer Saraf's cruiser. You have Mr. O'Keefe being covered in snow from the storm. You know where Mr. O'Keefe's body was. It's clearly visible on the cruiser camera from Officer Saraf. You have the testimony from each of the responding officers, anywhere from 5 to 12 feet off the roadway, and from the civilians as well. Ms. McCabe, Ms. Roberts, Officer Mullaney has 6 inches of snow on Mr. O'Keefe when he first sees him. Firefighter Kelly says that he couldn't even see Mr. O'Keefe until he was 5 feet away, in the darkness, in the snow, in the blizzard conditions. There's no footprints around the body. There's no drag marks around the body. There's no evidence of anything in relation to Brian Albert and Brian Higgins. Brian Albert and Brian Higgins spent January 28, 2022, traveling to New York City to go to a funeral for another police officer, for another department, who they didn't even know, traveled all the way down to New York and then came back before the blizzard, only to come back from that to go out drinking, to come back to Mr. Albert's house, to then murder another police officer who they did know, who worked for the same department as them. And then criminal mastermind genius that Brian Albert is, 28 years on the Boston Police Department, he's then going to just leave Mr. O'Keefe's body on his front lawn? Really? That's the conspiracy? What evidence do you have of that? You have statements that the defendant made to Sergeant Buchanan on January 29th. She was willing to speak but didn't want to give too much detail. Conversational tone throughout. She indicated that the night before they had gotten into an argument, something about what was fed to the children, nothing about the detailed arguments and incessant phone calls and everything else that you saw from the defendant and Mr. O'Keefe's phone on the 28th. She indicated that she got to C.F. McCarthy's around 9 p.m., started drinking vodka sodas, the men were drinking beers. When asked where she parked her vehicle, she said she parked on Washington Street across from C.F. McCarthy's, facing northbound on the same side as Waterfall. Same testimony that you heard from Ms. Kolakithis, observing the defendant going over to her vehicle, getting in the driver's seat, and the victim, Mr. O'Keefe, getting into the passenger seat. She said they left the Waterfall, were invited to her residence. She drove her and John to the location in Canton. She dropped Mr. O'Keefe off, did not see him walk into the home. She, being the defendant, stated she made a 3-point turn and then left. When asked about the damage to her vehicle, she indicated to the troopers, "I don't know, it happened last night." June 2022, you have that other recording of that other version that she now has evolved into, as far as stating to Sergeant Buchanan, "Are you aware that John was beaten up by Brian and Colin Albert? We're all in on the same joke, right? John was pulverized and my taillight was cracked." What evidence do you have of that? Mr. O'Keefe never went in the house. You have testimony from Nicole Albert, Brian Albert, Jennifer McCabe, Matthew McCabe, Caitlin Albert, Brian Albert Jr., Sarah Levinson, Julie Nagel, all indicating never went in the house. John O'Keefe's phone never went in the house, from the testimony and the data points that you have from Trooper Garino. You know how Mr. O'Keefe was dressed, and you know the defendant knew that. You have the testimony from Kurt Roberts, Jennifer McCabe, Matthew McCabe, Karina Kolakithis, Nicholas Kolakithis, Brian Albert, Nicole Albert, Brian Higgins, all indicated in their testimony, and the defendant knew, based on her questions to the firefighters the next morning, that Mr. O'Keefe was not dressed for the weather when he left the Waterfall. The weather was a weapon. You have the testimony about the car, the defendant's car being there in front of the house, moving multiple times. You have that from multiple sources. You have that from Matthew McCabe. You have that from Jennifer McCabe. You have that from Brian Albert Jr. You have that from Julie Nagel. You have that from Ryan Nagel. You have the testimony of Ryan Nagel, Ricky D'Antonio, and Heather Maxon. Ms. Maxon indicated she saw a male passenger, female operator, as the vehicle was turning. So remember, they're coming towards Fairview at the same time. The defendant, after conducting that reverse or 3-point turn on Cedar Crest, is then taking a right onto Fairview, while Mr. Nagel, Mr. D'Antonio, and Ms. Maxon are taking a left onto Fairview. Mr. Nagel indicates that Mr. D'Antonio then flashes lights. During that time, Ms. Maxon can see inside the vehicle. She sees a male passenger. She sees a female operator. They follow the vehicle as they're turning onto the street. Lo and behold, they're going to the same residence. They park. There's nothing in between them and the defendant's vehicle. They indicate that at no time do they see anybody get out of the vehicle. At no time do they see any damage to the vehicle, or it hasn't happened yet. At no time do they see anyone leave the vehicle and go into the house. The vehicle moves up on different successive occasions, as testified to by Mr. Nagel and several others. And then as they're passing that vehicle, Mr. Nagel indicates that he sees a female operator in the vehicle with the dome light on. Now, interesting, when I asked Mr. Nagel, as far as when Julie Nagel came out to the vehicle, did he roll down the window or did he open the door? He indicated he opened the door. And I asked him, what happened when you open the door? What happens when you open the door to a vehicle? The dome light comes on. So there's a reason I would submit, or the inference that you can make, is that no one sees Mr. O'Keefe in the vehicle because that's the moment he steps out of the vehicle. And then they're gone. The Nagels, Ryan Nagel, Ricky D'Antonio, and Heather Maxon drive away from that. We heard the testimony from Julie Nagel and Sarah Levinson, the peanut butter and jelly sandwich conversation they have with Ms. McCabe, which while they're pulling away from the house where everybody's attention is drawn, Ms. McCabe is turned around facing both of them in the backseat. Ms. Nagel is facing Ms. Levinson on the passenger side, looking out the window towards 34 Fairview Road. Ms. Levinson is looking back at Ms. Nagel away from that area, in which Ms. Nagel indicates that she sees a 5 to 6 foot dark blob on the lawn near the pole in the hydrant, which is just where Mr. O'Keefe is discovered the next morning. You have the testimony recall, and you have text messages in regard to Colin Albert when he gets picked up from Colin.
Mr. Lally, 5 minutes.
Yes, sir. Colin Albert, Miss Allison McCabe, Brian Albert, Nicole Albert, Caitlin Albert, Brian Jr., all indicating that he was picked up around that time at 12:10 a.m. You have the testimony from Chris and Julie Albert, his parents, as far as when he comes home, kisses them goodnight before he goes to bed. You have that testimony in regard to Chris Albert, as far as how John O'Keefe and the defendant come to be at the waterfall in the first place, as far as John O'Keefe and his nephew coming in early in the day, getting a couple slices of pizza, what are you doing later on, contained within those text messages. You have the testimony from Lieutenant O'Hara, Lieutenant Tully, Sergeant Mechanic, about those items being recovered. And in particular, the items being recovered on January 29th by that search team. What did Lieutenant O'Hara say? The items were found close to the curb. The items were at ground level. 3 feet of snow that they had to sift through in order to find those particular things. The detail or the delay in the recovery of evidence. The photos in the video, most of which you have in evidence, is earlier in the storm. This is before the 18 inches of snow falls down, before there's drifts and 3 feet of snow in places. They found the evidence where it had been at that same ground level, in the grass, under the snow, at 34 Fairview Road. We heard all of the medical testimony, which I would submit is consistent, from firefighter Formati to Dr. Rice. You heard the testimony regarding the defendant's blood alcohol concentration for Dr. Fowler and Nick Roberts, 93 milligrams per deciliter, 0.07 to 0.08% at 9:08 in the morning. You heard Mr. Roberts' testimony in regard to the retrograde extrapolation, 0.13 to 0.29, extrapolating back to the time of the operation. The defendant admits to drinking vodka. It's on the receipts from C.F. McCarthy's and from the waterfall, and you have the witness testimony in the surveillance video in regard to that. The forensic testimony that you have. In regard to the medical testimony, you have the sort of pattern abrasions, the clear plastic that's recovered by Lieutenant O'Hara and Lieutenant Tully on January 29th. The clear plastic that has the dimples on it. No one, not Trooper Paul, not anyone, at any point in time, ever said that Mr. O'Keefe's arm was out like this at the time that he struck and that he did a pirouette and then flew 30 feet in the air. 12 inches of abrasions that the doctors were, the biomechanical people were talking about yesterday, 12 inches and then 6 inches for the tail end, is easily solved by this. And the dimples on his arm are, that I would submit are consistent with the dimples on the taillight cover piece, are right around this area of the elbow. You have the testimony in regard to forensics, as far as Mr. Porto, Mr. Bradford. John O'Keefe's DNA is on that taillight housing, on the housing. His DNA is there to the exclusion as well of Sergeant Mechanic and Trooper Proctor. Mr. O'Keefe's DNA is on the exterior of the broken drinking glass. Mr. O'Keefe's DNA, and only Mr. O'Keefe's DNA, is on his clothing and his fingernails, consistent with Dr. Scortibello's testimony that there is no evidence of a fight or an altercation. There's no one else's DNA under his fingernails. There's no one else's DNA on his clothing. You have the testimony from Ms. Hartman, Trooper Paul, as regard to the damage that they observed, the dent, the scratches, the 7/8 of an inch hair. You have the testimony from Ms. Chart in regard to the mitochondrial DNA profile from that hair being consistent with the DNA profile of Mr. O'Keefe. You have the testimony from Ms. Valier and Ms. Hanley in regard to the microscopic pieces, 1/16 of an inch by 1/16.
You have 1 minute, Mr. Lally. Wrap it up.
Yes, Your Honor. All consistent with the pieces of taillight that are found within his clothing. Ms. Gilman, if I could. 605, this is what this vehicle looks like backing up at that speed for approximately that distance. There's another, years and years ago, started practicing in Norfolk County in Braintree, what is now Quincy. I eventually became a far smarter man than myself, eventually became President of the United States. His name was John Adams. John Adams once wrote, "Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence." What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over. Okay.
I literally have one sentence on you.
One sentence I'll give you.
From that facts and that evidence, I would submit ineluctably demonstrates her guilt on each of the indictments before you, and I would ask that you find it so. Thank you.
All right. All right. Thank you. Jurors, I have my instructions on the law I'm going to give you. My guess is it's probably about an hour. I'd like to start it now, but does anybody need a short break? You can take a short break. Okay, we'll come back in 5 minutes.
Jurors, leaving your notebooks under your chairs. All rise, jury out.
You are muted.
We are already at 85, so it's certainly heating up pretty quickly. Dew point temperature at 56. That's about as good as 85 degrees really feels, with a breeze about 12 miles per hour. So it's a really, really nice Tuesday that we're seeing. Plenty of sun, perfect, gorgeous summer weather. And over the next couple of hours, these temperatures in the mid 80s right now. We'll bump that up just a little bit before we start to drop it back into the 70s in the next few hours overnight. And right now, minimal cloud cover overhead, if at all. So we've just seen a few thin clouds in the air today. We are going to stay dry for both today and the first part of Wednesday before we get ready for a round of showers, heavy downpours, even some thunderstorms into tomorrow late night and in the early morning hours of Thursday. Today, though, enjoy it because we do have on Wednesday morning, we'll start off with sunshine and then get ready for those heavier pockets of rain. And we could see some isolated storms early on Wednesday evening about 6 o'clock. And then as the evening progresses, this is going to start to organize a bit better. We'll see more scattered shower and thunderstorm activity. And then that's going to be Wednesday at 9:30 p.m. Overnight, this really starts to progress, become more widespread. So I'd say Thursday morning, we could be waking up to a pretty wet morning commute, even some localized, some ponding on the roadways, not to be ruled out, and especially around the Cape and Islands in early Thursday morning hours. That's where we're expecting some of those heaviest downpours to occur Thursday morning. And now this does clear out pretty quickly on into our Thursday afternoon, where many of us will see the day turn to much drier air by noon on Thursday. So it'll look much, much better there, but we do still have to get through some gusty winds along the Cape and Islands, winds gusting to 40 miles per hour, 12 o'clock tomorrow. So it's going to be a very windy day for the middle of the week as we prepare for some of these heavier downpours Wednesday night to Thursday. And that'll actually put us in the next weather alert for Wednesday is going to be expected. That's when we get those round of heavy showers and even some thunderstorm activity, and the temperatures stay warm. So we've got highs today in the mid 80s, mid to upper 80s, 90 degrees for tomorrow. And then Thursday, still toasty, 84 for the high as we start to clear some of those rain showers out from the morning. And then on Friday, I think it's incredible weather, upper 70s, plenty of sun before maybe some rain chances come back to the weekend, Saturday and Sunday. So we do have a bit of unsettled weather here and there, but these next couple of days, enjoy the sun, Jordan, because it's going to be beautiful outside today.
And just like that, it'll be July. Alyssa, thanks. Some seniors across the U.S. are taking aspirin every day, even though they shouldn't be. Doctors used to recommend a daily low dose of aspirin to reduce the risk of blood clots. But in recent years, scientists have come to the conclusion that the risks outweigh the benefits. Still, research found nearly 30% of adults 60 or older are still using aspirin that they don't need daily. About 5% of them are doing so, too, without medical advice. A CBS News investigation found that billions of your federal tax dollars have gone to pump sand onto beaches all across America. It's called beach renourishment, and we've seen it tried in places like Salisbury. CBS national investigative correspondent Stephen Stock gives us a preview of what he found.
Bulldozers instead of children push around sand on Wrightsville Beach, North Carolina every 3 to 4 years, performing a costly and time-consuming process that is beach renourishment.
So beach nourishment projects look a little different depending on the geography. California, the Great Lakes, are here on the East Coast. We're in Wrightsville Beach, North Carolina, near Wilmington, and this is a typical beach nourishment project.
The primary goal is for the project to be, as it was authorized, is to protect the infrastructure of those beaches, those communities that otherwise would be at the peril with the waves and the storms and such, so they would be at risk.
While this may look like water, it's actually 30% sand and 70% water pumping sand onto this beach.
That's the goal here, to provide a buffer between the ocean and the community.
The process works like this. A dredge 30 feet down in the water starts pumping sand, then through the pipeline up onto the beach, more than 3 miles away.
It's simple but yet complex.
But the new sand only lasts a few years because the sand and tax dollars eventually wash away. Projects last on average between 3 and 5 years. We found more than 3/4 of all the projects nationwide were repeats, projects and money spent again and again. We talked to people who live in that community to ask, is this expense worth it? Who benefits? And could that money be better spent where it doesn't wash back out to sea? We will have that part of the story coming up. I'm Stephen Stock, CBS News.
And you can watch that full investigation tonight on WBZ News starting at 5. We'll be back right after this quick break.
I'm always looking to make my teeth whiter, but I can't go to the dentist to get those expensive treatments because when I've done it in the past, I have come out with sensitive teeth that were so sensitive I couldn't drink any cold water or anything hot. So here's my solution, and I hope it's yours too. This Mint Teeth Whitening Kit is going to get you whiter teeth in less than a half hour a day and none of that sensitivity. This is actually a dentist formulated product made for people with sensitive teeth like me. There's 32 LED lights with 2 different modes, violet and red light therapy. The violet light therapy is going to accelerate the whitening gel. And if you have sensitive teeth like me, the red light therapy is going to help reduce that tooth sensitivity and gum inflammation. So easy to use. When you're ready to whiten, just rinse your mouth out with water, apply the white gel max to your teeth, and then you take the tray, insert it in your mouth, do the violet light therapy for 15 minutes, and then the red light therapy for 10. Rinse out, good to go. Now, if you just want to protect your teeth, you apply the enamel boost gel on your teeth, insert the glow tray on, again, violet light for 15 minutes, red light for 10, rinse, and you are done. Right now, we are offering 53% off on Mint Teeth Whitening. Go to cbsdeals.com for this exclusive offer and a summer smile that you won't forget.
Welcome back, everyone. The summer swimming season in full swing, but many beaches and pools are struggling to find enough lifeguards. The American Lifeguard Association says the shortage can be blamed on the pandemic disrupting training programs and the notion that lifeguarding is viewed more as a summer job and not a profession.
The CDC in Atlanta has found that the drowning rate is actually increasing in the United States. And we think lifeguard shortage has a lot to do with that, as well as pools shortening their hours, eliminating programs.
The Lifeguard Association says more training opportunities and incentives like higher pay will go a long way in addressing the shortage. A power couple from New England is dominating the world of pinball. WBZ's Mike Sullivan shows us how their passion for the game brought them together.
From Brookline down to Everett, they played the silver ball. Ain't nothing like them.
Sure plays a mean pinball.
They can feel the bumpers, the digital counters fall.
When I discovered pinball, it was really just like, oh, there's a way to prove to people that I'm good at something. I will absolutely be doing that.
Zoe Vrabel is not just a pinball wizard, she's now the second best female pinball player in the world. Oh, she was one game away from being the best.
Sometimes there are just bad bounces that you can control. So right now whew, that was called a slap save.
She believes the game is 85% skill, 15% luck. She just didn't realize there was a 100% chance of finding love.
I found my life partner by playing in pinball tournaments.
His name is Daniel Rohn.
I've been playing almost 15 years.
He's a walking high scorer who just finished 30th at the World Championships in California.
Yeah, she was probably the only person rooting for me, but it was nice that she was.
I personally couldn't imagine not being with someone who played pinball as well as I did.
She is a rarity in the sport. Zoe says women only make up 20 to 25% of pinball players.
I would say if there is someone who is good at pinball and you like them, you're probably going to try and lock that down.
Perhaps that's really the highest score. In Everett, I'm Mike Sullivan, WBZ News.
If you're looking for love, maybe hit the arcade. You're watching WBZ News. We'll be right back.
It's my responsibility to give you instructions concerning the law. The instructions are divided into three parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part one of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion or sympathy, passion or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done.
Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer, during argument, made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They are simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations, and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted test or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you, and you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were, in fact, John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and/or the defendant. If you do not find it is more likely true than not that John O'Keefe, Karen Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can infer from the evidence that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight, that is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but You are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse, hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then, you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. And fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also in doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which, alone or in sequence, will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself to prove that the defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip and you should decide each one. The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe Rather, this is in the category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and/or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by failing to do something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The next indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further. save a little time for you. Right? As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of Massachusetts is that there can only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations all over again from the very beginning. Therefore, it is important that the alternates not discuss the case with anyone, including each other, for if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not begin deliberating until all 12 jurors are together in the jury room, and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartial impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not consciously aware of them, and I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing, and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitate to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
You are unmuted.
All right, so Mr. Clerk, will you choose the alternates, please?
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
All right, so ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right, so jurors, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me. authorizes. You may be seated.
It's to work with Mr. McDermott on the verdict slip.